Welcome back to another edition of Profit Matters Live, where we talk about your profit and why it matters. I guess that's sort of a good saying, right? I had never thought of that one before, but we're back again to talk this week again about construction, because the last conversation we had, we were talking about lien rights, and Ashley and I sort of got stuck. We were like, we're not totally sure. So we had to phone a friend and call in the expert. So we've got Stephen DePalma here. Stephen is with OGC. It's OGC Solutions, correct? OGC
That's
Solutions, correct. Based out of New York City and New Jersey. And he is really an expert in the law when it comes to construction. So we thought we'd bring him in today and have a conversation about what you can and can't do as a general contractor with your subcontractors. So Stephen, thanks for joining us.
Thank you for having me. Appreciate it.
So we were talking about there before we went live. We were chatting a little bit about the challenges that that you can have as a general contractor when you're dealing with subcontractors. Actually, I'm going to let you sort of set the ground here, because you're the you've been on that side of this, both on the accounting side and as an owner of a construction company.
So what we're running into is, used to, we paid when paid. And so your construction company or a subcontractor, general contractor, developer, and you're listening today, what was happening was we get a check for one project and then we pay the vendors, especially for the subcontractor. So we have those levels. And then what happened last week is we had a subcontractor say a vendor was requiring payment to get on a new job because we hadn't paid them for another job that we hadn't been paid for. And they were worried, what if we pay the vendor $200,000 for this expense, but we haven't gotten paid? Are we going to lose our lien rights? So we questioned last week, like, if we have 10 vendors for the project, can we just not pay one vendor and still keep our lien rights? You know, we talked last week, Steve, about if we take money from one job to pay another job, and you mentioned this also, that's a violation. We can't use those funds. So what if we have extra money in the bank and we're paying these vendors? What happens to our lien rights? And so is it, we need to not pay any of our vendors? Can we pay some of our vendors? Is there a dollar amount, even in New York or New Jersey? We talk a little bit about lien rights and when we lose our lien rights.
Sure. I guess if you sometimes subcontractors would need a prepayment or some money in advance to work on a project. And that's fine. You can prepay them and you won't lose your lien rights on that project. Because again, sometimes people need materials in advance and you can pay them in advance. The thing that we always would advise against, because I know in New York City this is a serious problem, is you're not allowed to use monies from another project to pay vendors on different projects. And that would be a violation of some trust laws in New York, where if you do that, you're like, when you hold money from one property owner for their project, you're holding that money in trust for those vendors. You can't then, as the contractor, use that money to pay vendors in other projects. It's a serious violation. It would hold the owners even personally liable, subject them personal liability if they were to do that. So that's like, I'm talking about using money from one owner to pay vendors on a different project. But if you're solely within your own project, you can pay your subcontractors in advance without losing your lien rights, because the person whose property is subject to the lien still owes money to the general contractor, because that's who their contractor's with. They have an agreed upon amount to pay them that is subject to change orders. So what we do with our subs, that's between the GC and the sub. The money is still owed between the owner and the GC. The subcontractor wouldn't have any more lien rights anymore because they're, should be paid. So their lien rights go away. But the general contractor should retain their lien rights because it's their contract with the owner.
Okay.
That makes sense. So just to that point, let's talk about that a little bit more, because I think maybe for folks who don't understand what lien rights are, number one, maybe you could talk a little bit about that, Stephen, just from your perspective. What are lien rights? Where do they come into play? How important is that? And how do contractors deal with that? Is that something you have to go to court for? How does that all work?
And then maybe our contract. Sorry, I'm going to tag on to that because I think you mentioned something really important, Steve. You said the GC has a contract with the owner. And so the importance of making sure that you have the right contract if you're a a GC, because I think that's when people start having major legal problems and you can't recover because your contract didn't cover whatever it is. Especially, I hear this term all the time where they talk about liquidated damages and things like that in construction. And people don't understand when they have to pay money because they didn't do what was expected.
Yes, I mean, construction contracts can be 20 or 30 pages, and you just sometimes an unsophisticated contractor would just see the dollar amount, and they start signing it and not really paying attention to the smaller details. And liquidated damages term saying if you don't perform by X, like there's going to be penalties for non-performance. Generally, in contract law, there shouldn't be penalties unless they're really addressed and supported by real losses that the owner would suffer. So when doing a larger job or any job, larger jobs, because you really want to get an attorney involved to review the contract, put in protections for you and advise you of hidden dangers that the owner may not be aware of. But then going to construction liens, as a lawyer, I've been litigating for nearly 20 years in New York, New Jersey. Construction liens are such a valuable tool for getting paid. Anytime I file the construction lien on behalf of my contractors or on behalf of my client, I get the attention, the quick attention of the property owner to get this paid real soon. Because a construction lien, basically, for people who may not know, is if you are a contractor and if you perform services that improve the value of the property, there's statutory law out there to protect contractors and subcontractors to make sure that they get paid. And what the law will give them are certain rights to go down to the county clerk and file a statutory lien on the property. And then usually you have to serve a copy of the lien upon the owner. This is when you get the owner's attention. Because right now there could be $100,000 million lien on the property. And this can cause problems from the owner. If they have a mortgage property, more often than not, there's a provision in their mortgage saying, do not allow any liens on this property, otherwise you may be in default. So that quickly gets their attention and they want to get this lien resolved. And if you're a subcontractor, the owner will start barking at the general contractor saying, what's this lien? Why am I being liened? Pay for it, bond it, take care of it, get it out of here. And so the subcontractor can just sit back and wait, hopefully, generally wait for payment. So that gets their attention. Also, the owner won't be able to refinance the property because if the bank sees there's a lien on the property, they're saying, well, we're not going to be behind this lien, get this paid. So it provides a lot of advantages to get paid. And also behind every lien is the threat of litigation down the road. So again, that gives another incentive for the owner or the GC to get these paid. The drawback is that there is a deadline. Liens don't go out into
forever, yeah.
Into time. Generally, there's a 1-year requirement to foreclose upon a lien, meaning to start an action with the courts and have the judge say, okay, you can foreclose upon a lien, and then it almost forced the sale of the property. Another reason why the owner would want to get this, lien paid. They don't want their property to be sold at auction. So that then incurs attorneys, complaints, and that's when the cost can get higher. But just filing a construction lien early on gets the attention, and it's not a lot of money that goes into it. Shouldn't be a lot of money that goes into it, and it's a good bang for your buck to get paid.
That makes total sense. Now, let's talk a little bit about that. I mean, I've had instances. I do some consulting for commercial construction, but I also have built some companies in the residential construction space. And I've had instances where GC goes under and the sub sues the owner of the property. Can we talk a little bit about that? Because it's something that actually does happen. And I had a friend that this happened to, and he's like, I paid the general contractor. And the sub's like, yeah, but I didn't get paid. How does that work?
There's a fine line there too, because again, yeah. I've had litigations in which a massive condominium project went up. Millions of people the subcontractor spent millions on the project. GC went bankrupt. And then all the subcontractors, like, they don't have a contract with the owner. GC's is underneath, they're getting pennies on the dollar in a bankruptcy action. but they're owed a ton of money. So, but we all file construction liens on the property. So now we have the owner's attention. Now, what you were saying before that, and again, then you go down the process that you know, on the owner would want to pay you.
Sure.
The problem that I think that you might have mentioned there before is what happens when the owner paid the GC everything. If a $100,000 project, the owner pays the GC the $100,000, but the GC takes the money to run, doesn't pay the chief subs, and all the subs are hanging out there saying, "What about me? What about me?" That creates a timing issue. Because what happens first? Did you file your lien, or did the owner pay the general contractor? And that's the key timing issue, because if the owner was unaware of your lien and pays the general contractor the full amount due, you most likely don't have any lien rights.
Yeah.
Because it's a law meant to protect the workers, but it's not meant to penalize the owners of the property. They're not expected to pay twice for work. They paid once. They paid 100% amount due to GC. You don't have any more lien rights. So when you're a contractor, especially as a sub, act early. Act early for not only to get your lien on notice with the owner before they pay everything, then your lien rights expire. And also with all liens, there are tight deadlines to file your lien. In New Jersey, commercial lien, you have to file it within 90 days of the last day of work.
Okay, great. That was my next question, because
That's great.
1 year to utilize it. So we need to file within 90 days of our last day on the job.
That's in New Jersey. All states are different.
A little
New
different,
York, New York is 8 months on
Okay.
a commercial project, 4 months for a residential single dwelling. So every state has different requirements. And if it's a good value money, good amount of money, I would highly recommend hiring a lawyer to do it, because construction liens are statutory rights. So when the court sees a construction lien, they're going to check off every little box. Did you comply with the statute? Because if you did not comply with the statute, you can invalidate
You're
the
done.
lien,
Yeah.
and then possibly hold the owner subject to penalties for filing a frivolous or invalid lien. So there are services out there that provide for like do-it-yourself online. I think I've seen a company, I believe, called Level Set.
Right. Yep.
And that they assist you online in doing your liens. I've never used them, but I just know that when someone owes you a lot of money, they have good attorneys, they're gonna fight you.
Yeah, it's like I had a friend just recently said, "Do you know a cheap attorney and accountant?" And I was like, "No, I don't." Like,
Don't want that.
Right? That's the last person I'm going to hire is the cheap guy. You know, you want the person that knows what the heck they're doing.
You want a lawyer also familiar with the state law, because again,
Yeah, that's a good point.
New York, New Jersey, two different animals basically. Like in just kind of general advice, to all contractors out there. As Ashley mentioned, the terms of your contract are very important. One general term I would suggest is an attorney's fees provision, and that's basically saying that if any party, it usually has to be a fair provision, but if you have to enforce this contractual obligation in court, that you'll be entitled to attorney's fees. Because as I mentioned before, things are good for the contractor, subcontractor. You have leverage until it's time to go to court, where now you have to start paying an attorney. So if you have to pay those fees, you want to be able to recoup those fees. But another very important lesson here is do not include attorney's fees in your construction lien. If you have $100,000 project, the owner agrees to pay you $100,000. You can't say $100,000 plus I've already paid this guy attorney $10,000 to do this lien, or however amount of money. The lien is only allowable for the contractual amount due.
Okay,
Makes sense.
that's really good. I have a question. I heard you say statutory lien, and I hear a lot of time a mechanics lien. Is there a difference in the two?
That's a great question.
Yeah, I use them interchangeably. It's just a name. In New Jersey, they're construction liens. In New York, they're mechanics liens, just by the nature. But they're basically one and the same.
Okay, cool.
They're all basically built by statute. So
Yeah.
courts, I've challenged these many times. Courts, a good defense attorney will say, "Well, this wasn't you you didn't file this on time, you didn't serve it on time, there wasn't a written contract. New Jersey requires written contracts. New York, no. So there's so many differences from state to state.
Stephen, what are the other risks that you're seeing right now? I mean, all over your website, it talks about managing risks, right? So this is one for sure. With the market shifting and adjusting and changing as it is because of materials costs, labor costs, all of these sort of things, that all brings a lot more risk into some of these equations. I've seen this happen particularly with commercial, where it's like, look, we signed the contract a year ago, but we don't even break ground for another year. Materials cost, we have no idea what materials costs are going to be. I mean, it would be impossible to even predict that. So what are other risks that you're seeing with the clients that you're dealing with, specifically in the construction industry?
In the construction industry, I get things, as you mentioned before, when you have contracts that have prices with uncertain terms in the future, basically you want to have a solid contract at the base to protect against those risks that may be unknown regarding fluctuation in valuations. You can have, to protect the owner, you can have a guaranteed maximum price contract saying no matter what, this can go in, this project will not exceed this price without, of course, a proper change order. That protects the owner in the uncertain times, and vice versa. With increased costs on the other end, you can have variations in the contract to protect the contractor and the subs to protect against the increase in materials as well. So it's just basically what party you're representing in the contract and looking to protect those interests.
That makes sense. You mentioned change orders too. Can you talk about that a little bit? One of the things that I've contractors are not real good with change orders in general, right? I mean, there's lots of, well, can you do this? Well, sure we can. And then it never gets written out into an official change order that's signed off by all the parties. And I think a lot of that happens particularly on the fly, right? Where it's like, well, wait a second, can we just move it over here? And we're in the middle of framing. So it's like, well, sure we can. But then we have to move HVAC lines, we have to do all sorts of other things. I mean, do you see much litigation and much challenge with change orders? Is that something that comes up frequently?
Absolutely. There's always issues with change orders. And basically a change order is an amendment to the contract, because the contract will say it's $100,000 job based upon this. And then you start the contract, and then you can say, well, the foundation isn't as was represented by the owner. There has to be a change to the contract that wasn't anticipated. And then you need to have basically a separate amendment to the contract. The change order is an amendment. Right. Or basically if the owner says, okay, I wanted a butcher block countertop, and now I want a marble or granite countertop. Well, that may be an increase in price, and we need to have a special change order. As being a contractor, you got to document everything. I even suggest taking photographs of everything, because that's to protect your rights. Because down the road, the owner might say, this you gave it to me cracked. And I take pictures of it here, it wasn't cracked. Take pictures of your job, videos of your job. I know many people don't really want to do that, but it's just always protect yourself, but document everything. And then sometimes you may have a change order that doesn't have a fixed price. So you may enter into an agreement, which is called a time and materials contract, saying, I'll put my workers on it. They get paid $50 an hour, and I'll bill you for my time. I estimate it, but we don't know how long it's going to take. Hopefully I sign off on it, and it'll be a time and materials contract. In New Jersey, again, every state's different. If you want to enforce a lien, it has to be a signed contract. New York, no. So if you don't have a signed contract, you don't have any lien rights. I had a client come to me, goes, here's my contract, here's my change orders, here's my time and materials contracts. I'm like, well, this isn't signed. I can't lien that. This isn't signed. That. And as an attorney, my biggest panic set is, when was the last day of work? That's always the biggest thing, because that's when the clock starts ticking. A contractor may come to you, you may have 90 days to file a lien, and they come to you day 70. I'm like, okay, I need to drop everything and do this. And just kind of one last point though, for anyone listening, regarding the last day of work scenario, because you may have completed the job and then you go out 7 months later to do a punch list of work or do some warranty work. That generally that does not restart the clock. Punch list work and warranty work really do not restart the clock. It's basically, what is the last work you did where you kind of demand full payment on the contract. And so
That makes total
before,
sense.
generally don't like punch list of work, warranty work. So when was the last real thing you did for payment on the contract? That's
Yeah.
the last work.
Makes sense. Yeah. Ashley, anything else? I think we covered a lot here. This was really good. It was very informative. And thank you, Stephen, for
No
being
problem.
with us, because it really, I think it solidifies the point that if you're in this game, you need to be very detail oriented and you need to have a good attorney.
Yeah, I mean, you can't protect your profit unless you're protecting your contract. And that's what I really think everything was about today. If you don't do the steps ahead of time, well, then we can't even manage your accounting on the back end because you just lose it all on the front end. And so I think
Yeah.
that's really important. We have referred a lot of people over to OGC Solutions. We love these guys. And like Steven said today, he's been doing this for 20 plus years, expert in construction. So if you're listening and you're a construction owner, especially New York, New Jersey, great group to reach out to. We had somebody who's in Colorado who reached out to you guys
nice.
just to work on updating their contracts. And so there are things that you can do, not even being in that state. And so just want to really thank you for being
Yeah.
I guess
Thanks.
one
Yeah.
plug, if I may, for a firm, like
Please.
our firm acts as a virtual legal department for small and mid-cap companies.
Okay.
And we're made up of about 17 plus attorneys. Each has a wide variety of experience: litigation, commercial law, employment, construction, insurance, and the list goes on. What especially differentiates our firm from others, from our competitors, is that we offer a fixed fee model. And so we're actually similar to a true legal department, that we
Yeah.
control costs, and you're not going to pick up the phone, I'm getting billed for it. We give cost control to our clients, and through this process and acting as an outside general counsel for them, we build a relationship with them, and we act as a strategist, and we look out for their best interests as well.
Nice.
awesome.
Well, thanks for being with us. And thank you all for joining us here on another episode of Profit Matters. We'll see you next time.